Dear students, today we are going to discuss the terminology Doctrine of Promissory Estopel and Nudum Pactum. These are two important terminologies in relation to business law or business regulation. So first of all, we are going to discuss the word Estopel. Estopel can be explained like this. The person making the representation or promise becomes bound by the same if another person has acted on the faith of such promise or representation. The promisee can ask for enforcing the promise even if there is no consideration. That is doctrine of promissory estoppel, we can say. That means if one person make other person believe that he is going to do something as a part of the contract, and the other person is accepting that and entering into the contract, and thereby the first person cannot withdraw from the contract, and he is supposed to or obliged to complete the contractual obligations. So we will look into an example. Mr. X establishes an industrial unit on the faith of tax concession announced by a state government for a particular specified period. The state government is bound by the estoppel and cannot withdraw tax concession earlier than promised by it. So this is a contract between a state government and Mr. X. So in that condition, the government has promised to give tax concessions to the entrepreneurs. So if there is any financial difficulties, the government is not supposed to withdraw the contractual obligation, and if government is withdrawing from that contractual obligation, Mixer X can sue against the government and get the tax concession. So this is called doctrine of estoppel. So on the basis of the faith on the promisee, if the promisee acts on that, he is supposed to get benefit of the contract in full. That is, even if there is no consideration as a part of the contract. This is called doctrine of promissory estoppel. And the second term we are going to discuss today is Nudum Pactum. This is a very interesting term, I think. So the word, so for every consideration is an essential forming part of the contract. We know that. No consideration, no contract. That is the stated statement already in the Indian Contract Act. If there is no consideration, there is no contract. So Nudum Pactum means naked promise. Naked promise. That means there is only promise without consideration. So for example, if Arun promises to pay rupees 10,000 without anything in return, this is a bare promise and gives no right to enforce contract. That means this is without any exchange of goods or services. The Mr. Arun is freely giving 10,000 rupees to his friend. So there is no nothing in return in this kind of a contract, but this gives rise to the what we call Nudum Pactum or naked promise, and subsequently the contract is getting void. But as per section 25, an agreement without consideration is void subject to certain exceptions. Normally, an agreement should have consideration, but in some cases or in some exceptional situations, we can say Nudum Pactum doesn't stands. That means even without consideration, we can move ahead. So that we will discuss detail in the coming slides. So Nudum Pactum actually means naked promise. That means a promise without any consideration, that we can say. So next we will look at the exceptions. That means no consideration, no contract is the preferred statement, but there are some exceptions. So first of all, it is if the contract arises as a part of a natural love and affection. See, if there is a take the case of a husband and wife. At the situation where they have natural love and affection between them, they are entering into a contract, not just a contract, maybe an oral contract. So they and the husband says to the wife that he will give a maintenance, or he will give some kind of monthly payment to wife for her normal livelihood, dailyhood. So that is a kind of a contract or oral contract arising out of natural contract, natural love and affection. But if that same contract arises when there is a dispute or quarrel between the husband and wife, that contract doesn't stands without a consideration, because that doesn't appear or doesn't arise out of natural love and affection. A written or registered agreement based on natural love and affection between the parties standing in near relation to each other is enforceable even without consideration. So we have to understand two, three things here. First of all, we should have a registered or written agreement based on natural love and affection, and standing in near relation, that means close relation should be needed, and it must be enforceable when the contract is even considerable or valid even without the consideration. So that is the first case we can say. Second one, compensation for services rendered, we can say voluntary services. In order that promise to pay for the past voluntary services be binding, the following essential must exist. The act must be done voluntarily for the promiser, or it must be something which was the legal obligation of the promiser. The promiser must be in the existence at the time when the act was done. The promiser must agree now to compensate the promise. For example, B finds A's purse and gives to him. A promises to give B rupees 500 or 5,000. This will be a contract valid without any formal consideration. So in this example, B is actually doing a voluntary service to A by giving back the lost goods. So actually, these kind of conditions are satisfied here. Here, B is doing a voluntary service, and it is a legal thing, which legal obligation that B is doing, and the promisor is existing, and the promisor agrees to give compensation. So in such cases, this contract exists, or even without consideration, the contract can be existed. And the third case is time bad debt, where a promise in writing signed by the person making it or by authorized agent is made to pay a debt barred by the limitation is valid without consideration. For example, A owes B rupees 2,000, but the debt is barred by the Limitation Act. It is an act prevailing in India. A signs a written promise to pay B rupees 1,000 on account of the debt. This will be a valid contract, because some debts will be time barred due to the Limitation Act after some specified period. So even after that, then there is no contract exists as part of the Limitation Act. But even later on, those persons can enter into a contract to fulfill the debt obligations. So that contract also will stand in this case. The fourth one is actually completed gift. In this case, the rule no consideration, no contract shall not affect the validity as between the donor and the donee of any gift actually made. Thus, gift does not require consideration. See, for example, if a father or maybe any relative can transfer his properties to another relative or any other person of his interest, if that asset is generated by himself, so that is a kind of a gift to another person. The person who receiving the benefit is not returning anything as a part of the transfer property. So this kind of contracts will exist even without consideration. And another thing, very important thing which related to this is that these are completed gift, means if once it is transferred to another person, it cannot be reversed back as a part of the contract. That is a very important thing. Another one, it is agency. According to section 185 of the Indian Contract Act, no consideration is required to create an agency. That means I can appoint a person or an institution as a on behalf of me to do any kind of responsibility of my own. So I don't need even to give a consideration for the agency services. And last one is remission. No consideration is required for an agreement to receive less than what is due. This is called remission in the law. See, this is an agreement that can be made with any persons, that maybe in case of some shops or any kind of wholesale purchases, we can receive what we are supposed to receive. That is something which the buyer and the seller can decide. So that means why this is applicable, because in consideration essentials we have discussed that consideration need not be adequate. So consideration should means that something in return. That means it must be something. That means we don't need adequate consideration. So remission can be allowed in case of a contract. So these are the different exceptions to the word contract without consideration, or Nudum Pactum, we can say. So today we have discussed two terms. One is Estopel and one is Nudum Pactum. Both are related to the consideration of a contract. So I hope this session is beneficial to you. Hope you will catch later in the coming sessions. Thank you for watching.